Welcome to the Roetzel Health Law Hotspot. Health Law Hotspot is a podcast for physicians and health professionals that covers the legal issues and trends that affect the healthcare industry.
On February 3, 2020, the U.S. Department of Health and Human Services published a bulletin to remind healthcare providers that the HIPAA privacy rule continues to limit disclosures during the novel coronavirus outbreak. The bulletin notes that healthcare providers may disclose a patient's protected health information as necessary to treat the patient or a different patient or to a public health authority such as the CDC. Providers may share protected health information with the patient's family members or other persons identified by the patient as involved in the patient's care. With the patient's verbal permission, or if it's reasonable to infer the patient does not object, providers may share information about a patient as necessary to identify, locate, and notify persons involved in the patient's care of the patient's location, general condition, or death. If the patient is incapacitated, providers may share that information for these purposes if, in their professional judgment, doing so is in the best interests of the patient. A healthcare provider may also share relevant information about the patient with family members or other persons involved in the patient's care if the healthcare provider determines, based on professional judgment, that doing so is in the best interests of the patient. For example, a provider may determine that it is in the best interests of an elderly patient to share relevant information with the patient's adult child, but generally could not share unrelated information about the patient's medical history without permission. A covered entity may share protected health information with disaster relief organizations, such as the American Red Cross, that are authorized by law or by their charters to assist in disaster relief efforts, for the purpose of coordinating the notification of family members or other persons involved in the patient's care of the patient's location, general condition, or death. It is unnecessary to obtain a patient's permission to share the information in this situation if doing so would interfere with the organization's ability to respond to the emergency. Healthcare providers may share patient information with anyone as necessary to prevent or lessen a serious and imminent threat to the health and safety of a person or the public, consistent with applicable law and the provider's standards of ethical conduct. Thus, providers may disclose a patient's health information to anyone who is in a position to prevent or lessen the serious and imminent threat, including family, friends, caregivers, and law enforcement without a patient's permission. The bulletin stresses that the HIPAA privacy rule must be observed even in emergencies. For example, it prohibits reporting to the media or the public at large about an identifiable patient or their treatment without the written authorization of the patient or their legally authorized personal representative for healthcare decisions. In addition, for most disclosures, a covered entity must make reasonable efforts to limit the information disclosed to that which is the minimum necessary to accomplish the purpose. Providers may rely on representations from the CDC and other public health authorities that the requested information is the minimum necessary for the purpose, so long as that reliance is reasonable under the circumstances. For example, a covered entity may rely on representations from the CDC that the protected health information requested by the CDC about all patients having or suspected of having novel coronavirus is the minimum necessary for the public health purpose. In emergency situations, providers must continue to implement reasonable safeguards to protect patient information against impermissible uses and disclosures. They must apply their role-based access policies to limit access to protected health information to only those workforce members who need it to carry out their duties, and must continue to apply the administrative, physical, and technical safeguards of the HIPAA security rule to electronic protected health information.
The Roetzel Health Law Hotspot is made available by the firm and its attorneys for educational purposes and to provide general information, not to provide specific legal advice. Use of the Roetzel Health Law Hotspot does not create an attorney-client relationship between you and the firm or any of its attorneys. The Roetzel Health Law Hotspot should not be used as a substitute for competent legal advice, and you should contact an attorney in your state about any legal needs or questions you may have.